ceremonies.
Well, good morning. I'd like to call the meeting to order. Thank you all for coming. This is such a great group, and I know for a lot of you, it was a long drive, so we certainly appreciate the effort. I'd like to introduce our board, and I'll let them introduce each other, starting with Gail at the other end. Just your name and what, where you live, what your community is.
Gail Husbands. I'm from Pensacola, talking about long drives. And I live in Azalea Trace.
I'm Gary Hughes, Region 2 Director, and I live at Penny Retirement Community, Penny Farms.
My name is George Dan. I'm the Director of Region 4, and I live at Indian River Estates in Vero Beach.
Good morning. My name is David Bayer. I'm Director of Region 5, and I live at John Knox Village in Pompano Beach.
Good morning. My name is Ken Shanahan. I'm the current Vice President of the Board, and I live at John Knox Village in Pompano Beach.
I'm Pat Birdsall, President, and I live at Indian River Estates in Vero Beach.
I'm Betsy Russell. I'm from Fort Myers, Florida. I live at Cypress Cove, and I'm the Secretary.
I'm Jim Neely. I'm the Treasurer, and I live in Freedom Village in Bradenton.
Fred Faulkner, Sarasota, Florida, Glen Ridge, and I'm a Director at Large.
I'm Sandra Thorson, Director at Large. I live at Freedom Plaza in Sun City Center.
I'm Cindy Barber. I live in Cape Coral at Gulf Coast Village, and I'm Region 6 Director.
I'm Tom Geyer. I live in Gainesville at Oak Hammock at the University of Florida, and I'm Director for Region 8.
Okay, great. Thank you very much. And now I'd like to welcome Bruce Jones, the CEO of FLiCRA, this beautiful property.
Don't want to stand with my back to you, so I'll stand over here. I just want to welcome you all to Vickers Landing. We're delighted to be your host. We're delighted to host the Florida Life Care Residents Association and to see so many of you here. And thank you for making the long drive. I know it is a challenge sometimes to get to this little corner of our state. But if you are from the southern confines, maybe you've noticed there is an actual change of season up here. So a little cooler weather up in North Florida. So as you are very well aware, resident voices are in the very heart of every life plan community. So this association plays a vital role in making sure that residents across Florida are informed, connected, and empowered to help shape our communities. Having served on the board of Leading Age Southeast, I've had the opportunity to work with your leader, Bennett, on several occasions and have the utmost respect for him and his passion for what he does in serving you. Here at Vickers Landing, we're especially proud to serve as your meeting place. For more than 3 decades, we have sought to fulfill our mission of engaged community, unmatched service, honoring generations that matter. Meetings like this are a reminder that our success depends on partnership, residents, staff, and leadership all working together. So I hope you will find today's agenda valuable, the conversations inspiring, and the fellowship enjoyable. Please also take some time to enjoy our campus on the tour this afternoon and meet our team and see what makes Vickers Landing so special. So on behalf of our residents, our staff, and leadership, thank you for being here, and we're honored to host you and hope you have a productive and meaningful meeting. So thank you.
All right, in deference to time, I'm not going to do a formal bio on our keynote speaker, just to allow enough time for her to share with you and have enough time for Q&A. Our board of directors is not just going to go MIA. They're just going to go over there on the wall so they can, watch as you are watching the presentation. So if y'all want to take that little row over there if you want, you can turn your seats, but there's a row over there on that side if you want to go there. But Dr. Pearson has been a keynote speaker for our meeting multiple times over the years, and she's always a hit every time we have her. And Dr. Pearson, as you'll hear in terms of her bio, I've gotten to know her over the years. I think, if I put a title on it, obviously from the academic standpoint, I would call her the preeminent scholar on continuing care retirement communities, if you will, especially in the academic circles. She's going to probably share some projects that she's working on that hopefully we'll get involved in, or you will in some measure. But we're glad to have her back. And it's been a few years. I think the last time she was with us, we were in Pompano Beach. She's been a treasure to work with, just in terms of her awareness and, not only working with resident leaders, including our board and the National Continuing Care Residents Association, certainly involved with all the provider organizations and certainly the media that's been covering the continuing care model, especially in the last few years, that you'll hear some of those observations. And so she's definitely one of those go-to people for reporters at all levels because of her expertise. So it's great to have her here. As she always does, she stayed here a couple of nights and to kind of immerse herself in the culture. And then I think she's prepared for some probably candid questions from you all this morning. And so we're great to have her back. So thank you. Say this, we are recording her presentation, so we'll be able to send out a link to the presentation to not only you, but other members who were not able to be here and hear her this morning. So this portion is being recorded.
Thank you, Bennett. It's a real joy to be with the FLiCRA members again. As Bennett pointed out, it's not my first time at this particular rodeo. And I'm not even sure what year was the first year. One of these days, Bennett, we're going to have to go back and look that up. But every time I come to Florida, of course, I learn so much. That's the real reason I come. You think it's because you're going to learn something from me? No, it's the other way around. It's why I have anything to say at all. I'm going to give just 2 seconds of my bio. I teach contract law, nonprofit organizations law, I've taught estate planning, and I teach elder law. In large part, those courses reflect my interest in learning about continuing care retirement communities. When I first started teaching, I taught advocacy courses only. I was a trial lawyer by practice before I went to begin teaching. And so I became more interested in the transactional side of life. And then I started an elder protection clinic, and one of our very first clients was a group of residents at a continuing care retirement community in Pennsylvania. And when I said, well, what is a CCRC? I don't understand this. Okay, that began the education process for me, a process that's still going on. You're going to see at the beginning and end of my slides my email address. Feel free to email me. I don't always answer everybody, only because I get overwhelmed. But if you have something you want to share with me, if you want to share copies of your residents' contracts, I'm particularly interested in contracts. I keep notebooks of them, and you will see why. Because I'm always mining them for information. So just make a copy and send it on to me. I will welcome it. Probably the only person in the world you could send it to who will keep it. So there you go. What can I say? I have an exciting life. It is, in fact, exciting. So I put my title for this set of slides, it's really the slides as opposed to the program, Coast to Coast, talking with residents, listening to residents about rights and responsibilities. I'm very much involved in a little separate project right now that you're going to be hearing about it with Bennett's support. We're going to do a survey, and the other person who's doing the survey with me is another law professor, Natalie Martin. Natalie Martin, I'm going to tell you in advance, is a bankruptcy expert, so you can imagine what we're doing. But the survey is actually going to be about residents' understanding of certain rights and responsibilities. And so I'm waiting for the Penn State approval process to finish their job of looking at it. It's an exempt survey, so exempt surveys take just as long as a non-exempt survey. But it should come out probably, I hope certainly by the end of November, hopefully earlier. So that's coming up. So my overview of my subjects today, and I'm going to walk around a little bit. So I was going to talk about 3 individual residents, probably more than I should, but I'm going to make that shorter. I'm going to talk about state laws versus contracts. I'm going to talk about some trends along the way as I go. And then I'm going to get to insolvency because I've been asked to specifically to address that topic for reasons that we all know and don't want to know, and what happens in bankruptcy court. So I'm going to spend a little time there. Then I'm going to talk about advocacy and how residents can be effective with their advocacy. Then I'm going to talk about a new subject I haven't talked about in public before, family dynamics with the continuing care community, because I think that's more and more important over time. And then finally, I'll talk about one of the challenges I experience, which is getting good legal advice out there for future residents of continuing care communities and residents that are currently in continuing care communities. I have a hard time stimulating lawyers to want to know about this. Why they have to read the contracts too? And they want me to read them and tell them. They don't want them to read them. They don't want to read them. Anyway, but I'm working on that. Okay, so some people will know who these people are. The one you probably won't know is Paul. And Paul is probably the one that we all actually know. You just don't know the particular Paul. So Paul is my first friend in a continuing care retirement community. He was my next door neighbor before he moved into a continuing care retirement community with his wife. And he had moved from a big time corporation in the Philadelphia area. And after he retired, he moved to Carlisle, which is just outside of State College, they wish, just outside of the capital, Harrisburg. And he had family in Pittsburgh. So he wanted to move to the center of the state. And pretty quickly after moving into the townhouse next to mine and doing a beautiful job renovating it, it became apparent to him that it was not working. His wife was very uneasy being by herself in this place she really didn't think of as home. And it got to the point where she would sit in the garage with the door open while he did his laps of the parking lot because she didn't want him to go where she couldn't see him. So they began looking at alternatives, and they ended up in a very appropriate, great, well-run, as so many of them are, nonprofit CCRC not too far away from me in Pennsylvania. So it was also my first place to ever speak to residents at a continuing care community because he invited me back. He just passed away last month. They lived there 28 years. Yeah, so it was very, very, very successful. His wife passed away about not quite 10 years ago. And the best part was whenever I visited him, he would be out walking. And he could go any place in the community because she understood that this was a safe place for her too, no matter where Paul was. So I think of Paul as the example of why people pick a CCRC. It may not be for them personally, but it may be for the couple. Or maybe it is for them personally. Either one. You see both. And in that thriving community, Paul was like the volunteer extraordinaire. He ran the thrift shop. In fact, the very first note on his comment on his obituary in the newspaper, in the online newspaper, was people at the community thanking him for being the best volunteer they'd ever had. And so, that's the kind of thing that you really like to see in a thriving CCRC, which I see every day when I visit friends at communities. I talked about Jack. Some of you may know Jack coming in California. The thing I'm going to summarize with Jack, I just talked to him yesterday, and he gave me permission to say this. Jack was a career professional in insurance, an actuary, at the very highest level of understanding the present value of future money and how to structure insurance products appropriately. And he and his wife chose the CCRC in California, and Jack will admit he didn't do his homework. He thought he didn't have to. He thought regulators would be doing the kind of homework that he does for insurance companies. And he found out that isn't quite true all the time. So he's had kind of a sub-career, how we call it, of talking about continuing care communities from the dynamic of financial structure and particularly from residents' views on financial structure. Jennifer is the third person. I put her in because also she helps me span the whole country. So Jennifer, some of you also may know, her name is Jennifer Young. And she went into a retirement community with her, I think he was kind of a new husband, Jack, in her 60s. And it was in the kind of Houston, kind of between Houston and Dallas, as I recall the location. And unfortunately, it was one that filed for bankruptcy almost immediately. Yeah. So she had to learn all about creditors' committees. And finally, she pulled up stakes and said, "I'm leaving." And she went to North Carolina. She went to North Carolina with a very thriving community, but she's had to continue to maintain her knowledge of how it stays thriving financially by being involved. So I think that kind of spans all the different ways that you can be part of a community, right? You can be a resident who's happy and you're a volunteer and you're living your responsibilities through that. You can be responsible by helping other people understand what the risks are that Jack does. Or you can be like Jennifer and support a community both in troubled times and in good times and be still committed to the thriving community. Two very recent events also are relevant to what we're talking about. So in Pennsylvania, which is my home area, in fact, this is very close to me, it's just a few miles away, a CCRC network of companies, six CCRCs, relatively small CCRCs, run by Trinity Lutheran. I don't think I said the name right. Probably should say the name right. Spirit Trust Lutheran. Did a public statement that they were going to be seeking Chapter 11 sometime this fall. And they put out the public announcement because they wanted to allay concerns, because in fact they have what you might call a white knight who is available to take them over if that becomes the bankruptcy court's best understanding of what the best outcome would be. And one of the reasons why this community kind of got in trouble, well, it's in financial trouble. They started doing other things beside what they did best, run communities. So they ran a home care agency. They ran a hospice agency. And they're in a very rural area, so it's not easy to run any of that. You're running around, from community to community to do that, my guess is. They were hiring a lot of temporary help, and they just got into the red. And so they actually spun them off at the beginning of the year, and I think both of those entities closed, but they still found themselves with additional debt that was still tied to their corporate name, and that therefore affected the 6 CCRCs. The CCRCs are relatively small. They're not going to pivot easily to younger generations yet because they are relatively small and tend to trend towards an older population, I would think, probably. Very nice, very small, but very nice communities. But then, let's talk about Colorado for a minute. Has anybody heard about the story about Casey's Pond in Colorado? Yeah.
Steamboat Springs.
Yeah, isn't that interesting? So up in the mountains, in Colorado, a CCRC got themselves into financial trouble. We're going to go into Chapter 11, and the community is who got them out. The white knight was the community. Yeah, they did a fundraising. Northwest Colorado Health is now the corporate owner of them. But that is an extraordinary story. So it's 1 year after they went into Chapter 11. Chapter 11 for reorganization, just a year ago in October. And they've now emerged, and they seem to be doing really well. So, just because you're in bankruptcy court does not mean that you won't thrive, right? That's really important to know. Okay, yes, ma'am.
Well, before you get too far away from Jack Cummins, I think we should acknowledge again his generosity with donations to CCRCs, $10,000 at a time.
Very good. Yes, Jack Cummings he's generous with his time and his money and his knowledge. Yeah, no, he's really an extraordinary person. He was probably the number 2 person I got to know in learning about CCRCs, and I've spent time with him in California, digging through his brain so that I can learn more and more. He really is an extraordinary resource. Really, really important. I should mention too, anybody here from Ocamit? Oh, very good, very good. So one of my favorite people also is Karen Miller, who could not be here with us today. And so again, I spent time staying at Old Canon, learning about your reorganization when you did it, not in bankruptcy court, thank goodness, but it was still a reorganization. And she's another example of a bright, hardworking, committed volunteer who loves her community. Yeah, tell her hello for me. I'm so sorry that she's not with us today. Okay, back to this class lesson, everybody. Okay, approaches to regulation for state statutes. There are basically three varieties, in my opinion. One is what is a statutory approach called disclosure mandate. Oh, I'm sorry, I'm driving the photographer crazy. One of them is, and it's the majority approach. What the law, and I didn't understand this at first, there are laws that basically say, okay, we recognize risk here. We recognize that it's a type of insurance risk. And therefore, what we're going to require is a minimum number and types of mandatory disclosures to the public. And that means really it's putting you in the job of the regulator's shoes. You have to see whether the mandates of the disclosed information is giving you the information you need to make an informed decision. And it should tell you, you should not fear asking for additional provisions if you feel there's something missing. That's the whole idea of a disclosure statute, is that the public, and the public who's buying the product, is going to be the ultimate consumer of knowledge about the product as well, okay? So it puts you, in some ways, in an important seat with respect to how CCRCs are regulated. Excuse me, I'm not used to having a microphone right there, so I'm not used to having to avoid it when I talk. The second type of regulatory structures, and sometimes these are blended together. The disclosure model is pretty much all states. But sometimes they also include a minimum number of financial requirements in order for them to be licensed. So, what type of reserves do you have to have at the beginning of an operation? What type of financing arrangements do you have? Different kinds of concerns about how entry fees are paid in, particularly before there's anything that it's even been built. And that's when the greatest protections tend to exist by statute, is at the first stages of a new CCRC where, people are committing money without knowing what they're getting, right? It's in the process of development. And so there's definitely rules about when do you have to refund, how long that money stays tied up. The fact it should stay tied up, it shouldn't go to some other place in the meantime, is for those early stages of operation. And then third is what I call consumer protection, with CCRC residents specifically in mind. And those have grown over the years. Why? Because legislators listen. And sometimes it's also the regulators who listen, the unit of state government, that's supervising the entity. I've now gone through 4 different heads of regulation in Pennsylvania. Some of them ignore me, and they don't ever want to talk to me. I get that. And I have students who say that. But some of them call me up almost at the very beginning of their tenure and say, can I talk? I want to know more. And that's good because, we have some hope that they're going to stay a really involved person in regulation. And, we've got a couple of the most recent ones I think are. Okay, I just talked about state regulation, but now I'm going to spend more time on what I think is the bigger legal issue. State regulation, there's good regulators and bad regulators. I think regulators are only as good as they want to learn about the entity. And not just on a superficial basis, really. They need to read contracts too, right? But contracts are the key thing. So right now, the big trend, and it's been a trend for more than 10 years, is to have some type of traditional contract, whether it's a life care contract or a fee-for-service contract or some hybrid. And that's one price. But then offer different types of pricing structures tied to refundable fees. Refundable fees have been both great and troublesome in this industry, in my opinion. Okay? And the biggest problem is when you are paying sometimes double the amount that you would pay for the traditional contract up front as an entrance fee, or even more in some places, even more than double the price. Why wouldn't that institution want that higher price? So they're going to probably emphasize that refundable fee contract. In essence, what people are doing is making an interest-free loan to their company. So why wouldn't they want to do that? And one of the reasons why the funds have become refundable is historic. Back in the 80s, there was a wave of bankruptcies in CCRCs where people were also paying substantial entrance fees, nothing like today, but still substantial, but there wasn't any refundability in place. And so a friend of mine who's a lawyer said, well, we started coming up with this refundable fee concept so that people would say, look, we're going to use your money while you're there, and it was implied to take care of you. And then at the end, we're going to give you some portion of your money back. You're going to pay a little bit more to do that, but that will give you a sum of money with which to give to your children and do other estate planning, right? And so and it was a marketing tool, quite frankly, at the beginning. But then CCRCs, who are not foolish people, they're very bright people, realize this is a good source of funding that doesn't have the higher cost of funding associated with borrowing money or doing other types of money-raising ventures other than just pure charitable contributions. So now we will often see a 50% refundable fee. We might see one that's a 70%. We might see one that's a 90%. I've seen all three in individual institutions. And almost always they say something like, after 15 months, or whatever the month time is, you'll be entitled to a refund of whatever the percentage is, subject to another paragraph. Okay? That's the calculation paragraph. So you should always pay a lot of attention to that paragraph. And then they talk about monthly fees. Many people stop at the amount, how much you're going to get back, right? How much you paid and how much you're going to get back. But we lawyers would like you to read deeper into the contract. So let's look at some sample provisions that are in contracts. I've pulled them. The provisions I'm doing right now are from 2 different contracts in Pennsylvania, but I've seen them in other states. Okay, one of them is the conditions of refundability. So the conditions of refundability are often that blue language. You're going to get repaid when we get a new fee for your unit, right? And some of them will even be more transparent and say a new fee that was higher than your fee for your unit. So if they've discounted the price, they're going to try to discount your refund as well. So every effort will be made by CCRC to resell the residence as soon as possible after your termination, but all marketing, sales, and admission decisions regarding such resale shall be within the discretion of the CCRC. Okay, so you are in charge of when that unit is going to be resold. And in a CCRC where new units are being built all the time, you may even be at the very bottom of the list because your unit has a refund attached to it, all the new units don't. So they're, good faith, they will probably offer it, but they may have a nicer, fancier, whatever, bells and whistles that will allow the other one to be sold first. Okay, so that's a reality check. Okay, one of the things I'm seeing, and this is a small trend, it's not a good trend, but it's still small, but again, we need to keep an eye on it. Any amounts of necessary repairs, maintenance, and then anything that you didn't pay for your own care will be subtracted from the refund when you pass away. So there's a couple of places where I think they recognize that often the person who paid the admission fee is the person who gets the refund, right? They're usually passed away. And so it's family members. And family members may not even know what the contract said, right? So they're happy with any money that comes to them. So a few CCRCs I've seen have begun doing a discount for rehabbing the unit. That rehabbing the unit should be the cost of the, of the company, not the cost of a deceased customer. So keep an eye on that. We have litigation in Pennsylvania about this, and so far it's been successful for the family members. Okay, now we're getting to the real meat, the green paragraph. It was only if it was green in the contracts too, so we could find it. Okay, I'm going to read this. I don't normally read my slide, but this time I will. So, fees collected under the terms of this agreement shall be used for any purpose, for purposes set forth below. Okay? And then it gives a list of things. Most of it starts off sounding good because, of course, you want it to be related to construction, operation, maintenance, and improvement of this CCRC, right? Let's keep going. For any lawful purpose consistent with the corporate mission. Okay, we like that, generally speaking, too. Let's keep going. To distribute funds to affiliated entities. Who are they? C, fees for management or other third-party services. Who are they? C, to benefit any affiliated, let's see, where am I? E, interest or debt service on borrowed funds. Okay, we get that if it's for this property, right? What if it's for a related property? We've now said that it can be used for a related property. Transfers of capital between corporate units. The construction of new facilities or new retirement communities. And then just while we're at it, creating or operating new service lines. So you now made a interest-free loan to a company that can go beyond the community that you live in with what they're doing with the money, particularly if they've been so bold and so transparent in a weird way as to tell you that that's what they're reserving the money for, right? So keep an eye on that. When they say it, they mean it, right? I've never seen anybody that included that wasn't using money, in ways to do what I call development as opposed to strategic planning within the same community. Okay, then another red caution, refunds are not escrowed. So I get this. The portion of the entrance fee to be refunded after occupancy, if any, is not held in escrow or trust for the benefit of the resident after occupancy. Definitely true. Now, there may be, if you're one of the first wave of residents at the new community, it may be an escrow. Because and it may even be an escrow for 60 days when you first move in. That escrow for some period of adjustment while you're deciding if you're going to stay there and they're going to decide if you stay there, that may be an escrow. But those are separate paragraphs. It's not going to be an escrow for the rest of your time at the community. And in a way, of course it's not going to be an escrow, because if it was sitting in the bank account earning the lowest amount of interest on earth, it's not making good use of present value of future money, right? So that makes sense. But what's happening is now with the consumer protections, because of financial insolvencies that have occurred, some states are looking at regulations that say, okay, you may not have to reserve all the money, but there's going to be a scale of reserves and a scale of when you release the money according to how it's earned over time. Okay, so keep an eye on those trends. I think those are the two key provisions here. Okay, now I know this is where some people are going to have questions. What is insolvency? It's the basic inability to pay debts as they become due, right? And there's cash flow insolvency and there's balance sheet insolvency. And usually if you get into a debt situation, there's going to be negotiations that are going to precede anything that happens in a court, right? You're going to negotiate to see if you can resolve some of the debts, sometimes with a discount or some type of a haircut. Sometimes you're going to get new contracts that may spread the payments out over time to vendors, for example. And then if the debt situation is serious enough that they feel they need new money and new management, and maybe the old management saying, I'm just not good at this, then they might be looking for what's known as a white knight. Somebody to come in and take over your operation, and usually with some additional cash in their pockets to do key things, and the commitment to your same mission is usually what you're hoping for. Okay, You can, in some states, you have the potential for not going directly into bankruptcy court. You might end up with a receiver, a state individual, person, it's usually not a state official, but somebody who's viewed as being good at operations, coming in and serving as your new CEO, in essence, of that community that's in trouble. It doesn't happen very often, to be honest. Several states have the receiver option. North Carolina is one of the big ones that has a receiver operation, mainly because you have to have really talented people to come in and service those receivers. So you have to have talent that you can bring in. So they may say, no, we're not going to do it this time, and leave it to Chapter 11 bankruptcy. The big one is Chapter 11 bankruptcy. Chapter 11, for those who are brand new to this, and I hope you're all brand new to this, I don't want you to be sophisticated in bankruptcy law, is for reorganizations, okay? And Chapter 7 is for dissolution, a complete liquidation of any assets. We're hoping Chapter 7 will not happen. Okay, so Chapter 11 is the non-bad news version of going into bankruptcy court. It's not good news, it's just the non-bad news. Okay, so Chapter 11, what's our goal? Our goal is to facilitate management of debt so that the place will reorganize as an ongoing entity of the same type, still a CCRC. That's the goal when we're doing this kind of Chapter 11. And the key players are the debtor, and most of the time in Chapter 11 for CCRCs, the debtor is going to be called a debtor in possession. The debtor in possession is the same person that's been operating your place all the time already. They just now call them the debtor in possession, rather than a third party like a trustee or a receiver coming in to serve in that role. Okay? So we're trusting the same person who helped get us there, to get us out of there, because they often have the knowledge of how to do it. Creditors, and the creditors come in all varieties. So the secured creditors, generally speaking, are going to be the funding people who gave the money to build the place to begin with, okay? And most of the time it's going to be bond companies. And so they're going to be secured creditors where they have followed the law under, I think it's Article 9 of the UCC and state laws that give them the highest protection as a creditor, so that if something happens that leads to insecurity, insolvency, they're going to get paid first if there's any money with which to be paid, okay? And it's going to be very hard to get rid of them as a result of that. And then residents. Residents are almost always unsecured creditors. We'll talk about why that's true. And then there might be a trustee who can be an impartial person operating the facility, or at least supervising the operation. That doesn't happen as often as you might think it should. And then the U.S. Trustee's Office is separate from the trustee. They're like the oversight for the bankruptcy court itself. And so they have a right to weigh in on something if they don't think the bankruptcy court's doing the right thing. So the key steps in a Chapter 11, in my opinion, the first key step is, what's the disclosure statement say? So when you file your petition to be given the protections of the bankruptcy court in Chapter 11, you have to give a detailed disclosure statement, and you're supposed to disclose all creditors, the amount of the debt, the priority of the debt. You're supposed to give just unlimited almost information about the debt status. And good attorneys make sure in the bankruptcy court that happens, right? This is not some place where, brand new attorneys should be operating. This is where experienced people should be representing the debtor so that the disclosures are accurate. Because, by the way, if they're not accurate, they can't resolve the problem. You can only resolve what you know about. And if there's secret debts out there, those will not be resolved. They'll just hang out there. So disclosure statements are public documents. So you should be able to get them, okay? And then one of the things we'll quickly learn of normally is there going to be a prepackaged plan of reorganization offered in bankruptcy court? So I talked about the bankruptcy in Pennsylvania that's about to happen, or at least filed and is about to happen. They are going to certainly give a plan of reorganization with the new person, with the new company coming in, How are they going to manage the debt? What's going to be the plan? Who's going to have to take a discount on their, right to collect, that kind of thing. And hopefully everybody's agreed to it even, so that you can walk in and out of bankruptcy court quickly with the least pain possible. Because as long as you're in bankruptcy court, that's not good news for any CCRC on the planet. Because you have to be disclosing that you're already in financial trouble, right? So you want that to happen quickly. Any people here in Erickson facilities? Okay, one towards the back. Well, Erickson is one of the more successful Chapter 11s I've ever seen. Also, possibly the most complicated I've ever seen. And they filed in Texas. That's where you go if you have complicated bankruptcy cases of any type. It's well known, I was about to say notorious, it's well known for being a sophisticated court that handles bankruptcies. But the judge herself said of the Erickson, this is one of the most complicated set of financial transactions I've ever seen. Because it was several CCRC operations, some of them just on the development stages with interlocking finances. And so how are you going to resolve that? But John Erickson, bright person that he is, had a plan. And he had the White Knight set up. And it was a company that also ran CCRCs. Good friend of his ran it. I think Mr. Davis, as I recall, is his name. And they really, they knew they had the plan, and the plan was working. And the key part to the plan was that the new company reaffirmed the debtor's obligations under contracts for refundable fees, in fact, for all fees. So that is your goal in a Chapter 11. That's when there's going to be relatively little pain. That's what you want to support. That's what you want to help. That's what you want to encourage, that kind of a plan. Now, while you're in bankruptcy court, it may take a while. Erickson was unusual. It did it fast, and it was because there was a lot of money at play. It was also a time when there was a lot of money in play at a time when there was a lot of money in play in healthcare. A lot of money moving around right then. People were trying to find good, sound investments for their healthcare money, and CCRCs were viewed as a good, sound place. So if you're an unsecured creditor, you're going to get a committee you're going to be part of. Sometimes you'll have your own separate committee because you might actually have some priority and your interests may be different than the interests of the other unsecured debtors. And you're allowed to have a separate committee if you want to. And as long as you can convince the court you have a reason for it. One of the things that many people worry about, lawyers are so expensive. Well, this is the one time you don't have to worry quite as much about that. Because the court is going to decide how much money the unsecured creditors committee attorneys can charge and whether they're going to get paid, okay? And where they're going to get paid from the debtor's assets. So that's why you again want an organization that has enough assets that they're actually going to pay for that attorney or attorneys to represent creditors, including residents. And it's not the creditor, it's not a lawyer that's, in line or in bed with, the other debtors or with the debtor or the other creditors. It's your own lawyer. You should feel good about talking to them. They should be sophisticated. Sadly, it used to be that I didn't know very many creditors that represented residents. Now I'm beginning to know lawyers who represent residents. It's more of a thing than it used to be. You could also have an accountant. It's professionals is what can be paid for out of the bankruptcy estate to help the unsecured creditors understand the debt process and what's going to happen next. The other part of this is when you're in this arrangement, you're going to have a voice in approving the final plan. And you're going to want to consider approving that plan very carefully. That's going to be part of it. You're going to ask a lot of questions, and you're going to decide how you want to approve it. And it won't go forward unless, I suppose it could go forward, but it won't go forward in the same way if the residents do not approve it. So residents, again, have a lot of power during that process. And your goal, not the goal, but there's really two usual ways in which this works out. Either you have that pre-decided plan and it works, and you get in and out of bankruptcy court quickly, or maybe it's going to take a little longer and maybe it's going to involve an auction, a sale, some type of a bidding process maybe as to who will be the new director new owner of the nonprofit organization. Okay. This is a slide where I'm going to stop for a few minutes because I know you're going to have questions. I'm just going to say the 3 topics, and then if those of you who really want to ask questions, rather than just hear me yap on, can ask. So, can residents be better protected in the event of insolvency? Kind of yes, kind of no is the answer. State law has been trying for a number of years now. States have been trying for a number of years to find ways to give a better prioritization of residents' debts in bankruptcy court. The big problem is bankruptcy itself is a federal law process, and the U.S. Supremacy Clause says that the bankruptcy court has the power to nullify state contracts, and it can ignore state law altogether. So there's different ways that these are being tried, and one of them is the Texas approach, using a lien on real property in favor of residents. To my knowledge, I've only seen one case where the case even references that Texas law, and it is a senior community. I don't know if it was a CHRC, but it was a senior living community, and it was in 2019. It doesn't give a lot of guidance to me as to how that's going to work, so we don't know exactly how and whether the Texas law works. I think what happened was, I think there was an old provision about priority that was in the 1998 version of the Texas law, lien law, and then I think in 2015, I think there was a new version of it. But I cannot find a side-by-side comparison of the two. So when Jennifer Young was part of the bankruptcy in 2011, I think it was, no one mentioned to their residents who were in the creditors committee that such a lien existed. So that's why I think that the lien must not have had teeth as of 2011 and now has teeth as of 2015 of some kind. I don't quite know. I want to know more. So the truly drastic remedies for if you are at risk of losing your insurance fees or your prepaid health care, lifetime care, are 2 different concepts. So one of them, related concepts. One is look for tort theories that will say the officers and directors are liable, right? And usually the tort theory needs to be a fraud theory so that it won't be discharged in bankruptcy. And in Pennsylvania, we aren't at the forefront of much of anything in Pennsylvania, certainly not sports at the moment. But there is this concept of deepening insolvency. And it's a concept that you have been operating the company while ignoring your debts, and the debts just get worse and worse, and now you can't recover at all. And that's a breach of your fiduciary duty to the creditors. So normally, officers and directors have a fiduciary duty to the company, but when it's so insolvent that really the creditors are the only people left, it's a fiduciary duty to the creditors. And who else are creditors? Residents, right? So I think that's one way to approach the concept. Not every state recognizes deepening insolvency. Sometimes they have another name for it. Sometimes they'll call it breach of fiduciary duties. They will call it that. But that's the one time fiduciary duties tend to come in. And then, ironically, the goal, and this is not very hard to find anything written about, because there's going to be a non-disclosure agreement in any settlement. But in the settlement of the case that was in Pennsylvania, near Pittsburgh, I'm just blanking on the name, Covenants of something, Covenants of Old Hill, or Big Hill or something. Anyway, they had one where the residents did lose their refundable fee contracts. But they were permitted to sue the officers and directors in what's called an adversary proceeding for fraud. And they sued them, and their goal was to get errors and omissions insurance to pay for at least a portion of those individuals' bad behavior. And the errors and omissions insurance recognized they were going to lose everything. And also the officers and directors recognized they were at personal risk if there was an excess judgment because there's a big Pennsylvania case where there was an excess judgment for that kind of behavior, and there wasn't enough errors and omissions insurance. So normally what will happen is, I can't say normal, on occasion when these separate proceedings happen because people are losing the actual value of their prepaid, investments, it's going to be errors and omissions that's a target for refunding money to those residents. Now, should Florida adopt a Texas law lien procedure? I know that's one of the things on your agenda. I don't see any downside to doing it, and I don't think it would be everything's objectionable to people that want no limitations on how they use cash. But it shouldn't generate strong objections, because I haven't seen it affect lending in CCRCs in any state if there is such a lien. So they're going to ask for that lien to be subordinate to the financier's secured interest, security agreements, and you're going to have to live with that, probably. But I don't see any objection to that. The real problem is a deeper problem, in my opinion. The real problem is that cash seems to burn a hole in some people's imagination about what can be done, with the cash in other enterprises. And I have been in the office of a CEO that was one of an extremely thriving CCRC. He says, listen to this phone call. And he said, I get about one of these a month. It was somebody with a development plan they were selling to the CCRC. You could do more with your money. We know how much money you have. And here's what you could do with your money. And here would be the return on your investment. Why are we talking return on investment in nonprofits? Well, I'm not so sure about that. But it is, sometimes they can't resist the siren song of somebody who has a good plan. Rather than leaving it in the bank account, we all agree that's not the best plan, right? But that's the challenge here. Natalie Martin, one of my very good friends, professor of law at the University of New Mexico, wrote a great article about I think it's the dance of creditors in bankruptcy, but she's talking about CCRCs. 2000 Ohio State Bar Reviews, Ohio State Law Journal. Write me and I can send a copy to you if you haven't read it, but you should read it. What she says that is so compelling is don't do something that just on paper gives false assurances to new residents. Right? We as residents have to be honest too. Right? And so read her article. She and I are going to take a deeper look at the Texas lien provision. By the way, you should invite Natalie. She's busier than I am, so she might be harder to get. Although if she's busier than I am, I'm not even sure she's alive. But she's great, and she's a good speaker, and she knows everything about the bankruptcy code, and she's taught me most of it, thank goodness. Or what little I know, she's taught me. So that would be somebody you could do. Okay? Nobody stopped me yet.
Question?
Okay, question. There you go.
So, hi, I'm from FLiCRA.
Good.
And so we took great exception to the approach that was put forward in the 2025 proposed changes to the 4651.
Okay.
We did an analysis with our CEO, our owner-operator, and our bond. And they said that it would increase the take care of capital. Is there a microphone?
I'm sure that's true.
It would increase by about $6,000 a year for every resident.
Now that's an interesting number. I think I want my own accountant. Yeah.
So, we did it.
There's a microphone there.
We took great exception to that approach. We just asked our CEO before we came about Texas law, and he said he agreed with you. He didn't see any downside.
Yeah, I think that's probably right. I've run it now past about 5 different people I trust, and other than the potential to give a false reassurance, it does create some prioritization for residents, but probably does not jeopardize the the funding potential.
Yeah, that's right. Cool, thank you.
You're welcome. This is a good time to talk about advocacy, right? Because you probably thought, oh my gosh, I didn't have to do advocacy when I came to this community. Well, you never stop doing advocacy in life, right? Even if it's just trying to get your doctor to do something. Think about what's the right size for your advocacy group. Think about who your best speakers are. I'll be coming over to you. Think about what your common goals are. And also, in your mind, be very careful to think about what's a win. Do you really have to win the whole enchilada at the cost of destroying the financing that does need to exist for CCRCs? Maybe not. Really, the better, a lien is only as good as there's money in the place anyway, right? You don't want to have to go down that route. So anything you can do to support and help CEOs and CFOs do the right thing in the beginning is the better, right? Yes?
So I live in Arlington of Naples, which is an LCS community. LCS manages it. We know that well. They also own it. But who owns LCS? There is a web of ownership, of private equity. And there's no transparency on the ownership. We'd like to see the operating agreement of the LLC to see what kind of distributions and where it's going. And as you say, the ownership is involved in hundreds of communities, and the profits don't stay it just goes everywhere. What can we do? We all know that. A lot of us know that. What can we do about it?
Yeah. Unfortunately, the really bad news is this is a trend all across healthcare. And it's interesting how I always know when I've hit something that hurts in ways I didn't expect, because I get calls from people I never thought I would hear from because I said something. And recently I wrote about private equity in healthcare. And I said, is it possible that it's more part of the problem than part of the solution? Everybody needs more cash to run anything, right? But if the cash is tied up in non-transparency and they want a very substantial return on their investment that's unrealistic, I think that's a bigger problem. And, and I think you just have to keep, I don't know the solution right now. It's even so bad that I'm involved in kind of consulting on a case right now that's not a CCRC, it's a nursing home case. Pennsylvania has a bad law, I told you about a good law, but they have a bad law that only allows one party, in theory, to be at fault for a single act of negligence. So when the management company and the operating company are both found at fault by the jury, they said, no, the only party that has a duty of care is the operating company. The management company does not. Therefore, the management company is not liable for the portion of fault that was assigned to it by the jury. So that's on appeal right now. Insanity. The jury found that the management company's decisions on denying enough money to staff the operations, that's who was making those decisions, the management company. The operating company accepted it, yes, but the management company was dictating it because the management fees were in excess of what anybody would pay a management fee if it was an internal management company. And they had structured as a completely separate corporation. It used to be that you could pierce the corporate veil, a legal term, to get to them, but now you can't do that. They just operate as a completely separate company, and they're very careful not to have overlapping officers and directors and that kind of thing now. But this is a trend that's far beyond CCRCs, and now I'm starting to see it in CCRCs, and you've identified another example that I hadn't really started thinking about yet. On the far side.
One for this one for proximity, that's all right?
Yes, am I, okay, on the second. When do you want me to stop? 10 minutes ago?
He'll let us know.
Okay.
Mine's a short question.
Wait, we've got a mic.
Sorry.
Two questions.
I'm going to walk over there while you're talking.
Sure. Two questions.
Back to the lien issue and the tort liability and officers and directors insurance. Are you saying that in terms of the lien, that again, that's not impeding the bondholders? So it goes against other unsecured creditors?
Yes, it definitely goes against other unsecured creditors. It puts you ahead of the people who delivered food, for example, that kind of creditor. Service, other kinds of services. Oh, good, you got it. And one of the things I would really encourage you to think carefully through, because I can't tell how the Texas law actually works yet. The question is, where in the financing structure are you still subordinate to financing? Is it going to be every time they borrow money to do a new venture? A separate venture through your money? With a window through your money? I don't know. That would make me very nervous. So I think you have to really look carefully through how that works. And I was trying to find somebody in Texas who could tell me, and on short notice I couldn't find anybody.
Okay, but the gist of what you're saying, what I hear is that the bondholders would not object because they remain the top secured creditor and they get their money.
Probably they would not. I don't know bond companies well enough to know what they object to. But generally speaking, I don't think they would object.
Okay, second question. In terms of the tort liability aspect, that's going to require money, and that comes from the insurance company on those policies, unless you've got a really rich CEO or director. Are those policies sufficient to cover in any meaningful way?
Probably yes, because probably the errors and omissions are not 1 year's worth. They're probably not 1 year's worth of errors and omissions, right? It took them a while to get there. Yes, ma'am. That was dramatic.
So much of what you said to me sounds like for-profit issues. In a not-for-profit CCRC, do we face exactly the same things, or what's the big differentiators here?
Congratulations. No. I'm shaking your hand. Oh. Yes, you identified the issue. For years, CCRC, a good CCRC understands mission, a nonprofit CCRC, and they make it their mission. But there are also CCRCs that operate as what I might call a faux nonprofit, where there's a for-profit management board, a for-profit development board, a for-profit company that created the CCRC and put the management in place, and they don't have a tradition of charitable care, right? And that's different than what a for-profit. The for-profit has no tradition of charitable care except to the extent that they have a separate foundation, and the separate foundation is funded through residents' donations. That can exist, right? Okay, so yes, you're right. It is similar. Yes.
Could you please talk a little bit about the structure where the actual holder of the certificate of authority does not own the property that the facility operates on?
Right. I haven't had a chance to actually sit down and look at a case involving that. I'm sure it exists. And I'm sure it exists for precisely the reasons I was just talking about. They're attempting to insulate the property from liability for tort. I'm sure that's the reason it exists.
Do you have any idea how widespread that is?
In the healthcare industry generally, it's the #1 trend. Yeah, there are entire seminars you can go to learn how to do it.
All right, let's do maybe 2 more questions if we have 2 more. Wait for the mic.
I have a question about assets available to creditors and corporate structure. Like we have an OpCo-PropCo corporate structure. So OpCo does the operations, PropCo owns the property, so that if there's a bankruptcy, OpCo is bankrupt,
how to make it around that, other than, yeah, I mean, it is a challenge. That Texas law alone will not solve that problem for us.
Any other questions? Are we supposed to open the bar now? One more question.
Thank you very much for the talk. When you talk about this subject, you really have to divide CCRCs in three categories. The for-profit, the not-for-profit, and then this hybrid that you mentioned at the end, which is not-for-profit, but has some elements of for-profit. Meaning that they have some corporate governance structure where you have an outside management company that has rights. And that gets really complicated. So you really have to address the three of them. And because the solutions, I think, are different for each one. And you get into corporate governance issues.
Right.
And in a for-profit, you really have no real rights, and you've got to rely on the regulators, I think.
Well, you have rights in a for-profit, but the shareholders of the corporation have greater rights. And they're going to
restricted, let me put that.
Yeah. And hopefully they will listen to residents who are deeply unhappy. Sometimes that does happen. And I think corporations, for-profit corporations walk that fine line rather carefully, because the last thing they want to be involved in is a shareholder challenge. And those happen in for-profit corporations, and they don't want to be part of that. That's really expensive for the corporation. So that's why for-profits do hang in there and do a good job most of the time. And but I think it's with a difference. I see a difference in the culture myself when I visit nonprofits versus for-profits, pure for-profits. The hybrids, I think they have been pretty successful. I'll tell you why I like some of the hybrids. They have provided a way for middle America retirees to live in continuing care communities. They have made it more democratic, more diverse, usually larger communities, because they're trading off large size and sometimes smaller units for money, and more people rather than bigger spaces. But I don't object to them, to the hybrids. Okay, you've been great, audience. I'm skipping slides once again, I always do. And so, do let me know, let me hear from you. I will probably do a follow-up or two related to the Texas law, because I need to study it more now that you've informed me of how far along you're going with your proposals related to a Texas-style lien for residents. And I will put my short versions of what I'm thinking about on the elder law, profit law. It disappeared for a while. We had a platform that went under, and we moved to a new platform. So there it is right there. It's a .com as opposed to a .org before. And so please let me hear from you, and you can email me or you can read what I'm doing. There's a way for you to subscribe for free on there. It just sends an email to you with the latest post.
Thank you, Dr. Pierce.